We are in Las Vegas, Nevada, this afternoon, where defendant Robert Tellis is back on the stand testifying in his own defense. The former public official is accused of lying in wait at long-term reporter Jeff German's house before fatally stabbing him in his yard. Prosecutors say Tellis was upset over German's recent articles accusing Tellis of creating a hostile work environment and other corruption as a public official. Let's welcome in our guest for this hour. Trial attorney Nicole Brenecki is with us. Nicole, I want to go back to that moment where he's showing photos, his own evidence, and then he's breaking down on the stand. How do you think a moment like that resonates with a jury, all the while he really is talking about being the victim here?
Good afternoon. Thank you for having me. I am under the impression that Mr. Tellis is running his own defense against his attorney's advice, because as a practicing attorney, one thing I can tell you is that it's really not advisable to do what he's doing right now. I think that he believes that if he tells the story his way, presents evidence his way, that he can say anything and everything under the sun. However, I'm sure his attorneys explained it to him that his direct testimony that he's currently conducting is subject to the same rules of evidence as any other witness, which means that he literally cannot just say anything and everything. He needs to, he's bound by the rules. For instance, he cannot say things that constitute hearsay. So hearsay is a statement made out of court that you're trying to bring in your testimony, but you do not have the witness that made that statement with you in the courtroom corroborating it. So these objections that we heard so far, where Mr. Tellis's attempt to introduce some statements, well, unfortunately for him, it's not allowed to do so. He will continue to talk, objections will be asserted, and if these objections are proper, and I'm sure they will be proper because the district attorney is a licensed attorney and Mr. Tellis is not. I mean, he has a legal background, right? We know of that, but we've heard the objections so far. I mean, he definitely was trying to say more than is allowed, despite the legal background that he has. So the district attorney will then be making more objections, and these statements that are properly objected to cannot be taken into account by the jury or if there's an appeals process down the road. So definitely another thing that is incredibly important to mention is that he will be subject to probably a very brutal cross-examination. He thinks he can say everything he would like to right now. However, later on, the DA can very skillfully ask him questions about the things that are relevant to the subject matter of this case, which is the alleged murder. And only those things that are relevant should be considered by the jury. So we shall see how that strategy pans out for him in the long run. But I am really not hopeful for a positive outcome for him, given what he's been doing so far.
Oh, for sure. And your point being that even though this is a narrative, I think is well warranted, that he still can't just ignore the rules of evidence, even though we're not seeing the traditional question answer that we would see in a direct examination.